Today, we're digging into a fascinating legal mystery. It's a story that starts with a catastrophic infrastructure failure in a modern city, but the solution comes from a law so old it was written when steam engines were still the hot new thing. So, here's our roadmap. First, we'll look at the disaster itself. Then, we'll uncover the dusty old rule they used to try and solve it. We'll get into the core legal question, see what the final verdict was, and then we'll figure out why this one case from decades ago is still so important today. All right, let's set the scene. We're in Stockport, a town in Greater Manchester in the UK. On what seemed like a totally normal day, the ground beneath the city literally gave way, and that set the stage for a massive legal showdown. Now, it seems like a simple question, right? A pipe breaks, you find who's responsible. But when a public utility fails and it causes a huge chain reaction of damage, well, things get messy, fast. So who ultimately has to pick up the tab? And this was not just some small leak, We're talking about a large, high-pressure water main. It was put in back in the 60s to serve a massive tower block, which means it was constantly carrying a huge amount of water right under everyone's feet. And then, one day, boom, it just broke. So you've got this torrent of water, right? And it's so powerful that it literally washed away the ground supporting a nearby high-pressure gas main owned by a company called Transco. Suddenly, this critical and, potentially explosive pipeline was just hanging there in midair. It was an incredibly dangerous situation that cost a fortune to fix immediately. So, of course, the gas company, Transco, sued the Stockport Council, who owned the water pipe. Okay, so here's where the story takes a really interesting turn. Now, Transco's lawyers could have sued for negligence, the usual route, but that would mean proving the council was actually careless, which is really hard to do. So instead, they went digging through the legal history books and dusted off a much older and much more powerful legal weapon. They pulled out this legal bazooka, forged all the way back in 1868. The original case was about a mill owner who built a big reservoir on his land, which then burst and, you guessed it, flooded his neighbor's coal mine. Sound familiar? That case created a very powerful and kind of unusual rule for situations exactly like this. This rule is built on a concept called strict liability. And honestly, the best way to think about it is like this. Imagine you decide to keep a tiger in your garden. If that tiger gets out and causes chaos, you can't just say, "But I had a really strong cage." It doesn't matter. The very act of bringing that danger onto your property makes you responsible. It's liability without fault. You're the source of the danger. You're on the hook. Period. So for this old rule to apply, Transco had to prove these 4 things. Number 1, did the council bring a dangerous thing, all that high-pressure water, onto its land? Check. Number 3, did the water escape? Oh yeah, check. And number 4, did the escape cause damage? Double check. The first, third, and fourth points were a slam dunk. The entire multi-million-pound case hinged on just one thing, that second condition. Was this a non-natural use of the land? And this became the million-dollar question. What does non-natural actually mean? Does it just mean artificial or man-made? Or does it mean something more like extraordinary, unusual, something special? The answer was going to decide the entire case. And so, after years of legal battles, all that time and all that money, it all came down to interpreting just 2 words that were written in the 19th century, non-natural use. So this brings us to the 2 big arguments, head-to-head. Transco, the gas company, they're arguing, look, piping this much water at high pressure is inherently risky. It's a special kind of danger, a non-natural use of land, and so the council should be strictly liable. But the council fired back saying, are you kidding? Supplying water to a huge apartment building isn't weird at all. It's essential. In a modern city, it's one of the most ordinary, most natural uses of land you can possibly imagine. After making its way up the legal ladder, the case finally landed in the House of Lords, which, at the time, was the UK's highest court of appeal. The top legal minds in the country were about to set a major precedent for the modern age. And this quote from the lead judge, Lord Bingham, really just cuts right to the heart of the decision. He didn't see the water pipe as some unnatural danger. He saw it as a vital service, an ordinary part of modern life that benefits the entire community. He totally reframed the conversation. So, the verdict was in. Transco lost. The House of Lords ruled that this 150-year-old rule just did not apply here. The council was not strictly liable for the damage that the burst pipe caused. So what was their reasoning? Well, the judges basically said that the world had changed a lot since 1868. Supplying essential things like water and gas is a totally normal, routine part of our society now. They decided that the old rule was never meant for these kinds of activities. It should be reserved for cases where someone is doing something truly exceptional and unusually dangerous for their own benefit. Like, storing a bunch of industrial chemicals, not providing water to a community. So, a gas company lost a lawsuit about a water pipe. Why should we care? Well, it turns out this verdict had huge implications that go way beyond just Stockport. This case shows how the law has to adapt. It basically drew a new line in the sand, and it clarified who carries the risk for all the complex, interwoven systems of pipes and cables that our modern lives completely depend on. And here's the change in a nutshell. Before this case, the rule's focus was on any non-natural use of land, which was super vague. But afterwards, the focus narrowed way down to uses that are extraordinary and unusual. This pretty much shielded essential public utilities from the constant threat of these strict liability claims. And that's really the key takeaway here. The law isn't some static thing that's carved in stone. It has to evolve. This case is a perfect example of the courts recognizing that what was considered a non-natural industrial risk in the 19th century has become a totally ordinary, essential part of life in the 21st. The law simply had to catch up with reality. And that leaves us with a final, really important question. I mean, think about the risks we live with today. Self-driving cars on public roads, AI making critical decisions, private companies launching thousands of satellites into orbit. As our world gets even more complex, this case forces us to ask, how do we decide who bears the risk when things inevitably go wrong?